So just so we know, we're going to start recording. As remember that if you're not okay with the recording, to either keep your video off or just say anonymous as well.
It's so exciting seeing so many different people introducing themselves in the chat.
It really is. I honestly have to say, every morning I would wake up at the participant list and like see all the new people, and I'm just big fans of you all. Like it just makes me so happy. It makes us so happy. It really means a lot that you guys are here and that we can also have this such an important knowledge in these very important times. Okay, let's start maybe in about, should we get started, Natalia? Okay, so I'll just do a quick introduction myself. Hello, everybody. I'm Shellen, along with Ashwarya and Dr. Alexandra Harrington, who will be our amazing lecturer today and for the consecutive sessions. She has very excitedly volunteered her time to be here, and she's very passionate about the topic. I come from California. Typically, my climate, I've always been an outdoorsy nerd, I like to say, but my climate work was really inspired by the California wildfires, which hit my home area in 2017. And as a result, I got to participate in the recovery efforts and really see firsthand. I've lived in India, I've lived in Netherlands, and I'm currently a member of the the Plastic Action Working Group, the Children Youth Major Group, as well as many others who are here. And I'll hand it over to our global coordinator, Natalia.
Hi, everyone. It's amazing to be here. My name is Natalia, and I'm CYMG's global coordinator. I'm originally from Poland and currently based in South Korea. I'm incredibly excited to have so many people join these sessions. And from my side, I just want to say a huge thank you to the CYMG team that has put this series together. It's absolutely amazing work, and you're in great hands. And I'll hand it over to others for introductions, right, before coming back.
Sorry, Natalia, can you repeat that?
Oh yeah, I don't know if Alexandra, for example, wants to introduce herself as well before we say a few more words about CYMG.
Oh, make sure you unmute yourself, Alexandra. Oh, here. There we go. Here.
There we go. Okay, I was going to say, finally found a button to keep me quiet. It's amazing. Many people would like that to be a thing during the negotiations. Anyway, so lovely to meet all of you, and a huge thank you to CYMG, to Shellen, to Jimena, to Natalia, Timothy, Aishwara, everyone who's been involved in this. This is something that Shellen and I kind of cooked up together in Busan. We started having these discussions during some of the downtime at INC5, and just saying that, really felt that a number of people needed access to information that would allow them to understand international law and also the treaty process, because it is such a different world and we need so many voices to be in it, but it is often so difficult to figure out the landscape and how you participate and what participation means and what things mean in the process. So that was the origin of this, and I am just stunned at how quickly it's grown, and really to all of you, those of you who are here online, those of you who are watching the recording. Just as quite a quick background, I am Dr. Alexandra Harrington. I have a PhD in international law from McGill University. I teach at the moment international law at Lancaster University in the UK. I am British and American, and also now spending a great deal of time in Canada. I'm currently in Canada, in Montreal at the moment. I will be based there in the fall. And my role, my major kind of method of meeting everyone involved in the treaty process is as the chair of the International Union for Conservation of Nature, the IUCN's World Commission on Environmental Law. So we have a number of different commissions within the organization as its task force chair. So we have a task force on the Plastic Pollution Treaty. And so I am the chair of that task force and provide a lot of legal insights and governance insights to the general public and anyone who asks typically, as well as to various countries who have asked me to help them throughout the process. And I do currently sit on the legal drafting group for hopefully for 5.2, if we have text to clean and to look at, where I am representing Guinea-Bissau, actually. So I have the opportunity to work with a number of different countries, and it truly is a privilege to do so. And I did want to mention for those of you who are online that we will obviously have translation and that will be explained to you. But if you have questions in French or in Spanish, please feel free to ask them to me in either of those languages. And obviously, bienvenue et bonjour à tous et hola. It's a pleasure to see all of you. So thank you very much. And do I give back to Shellen? Do I give back to Natalia?
Natalia.
Natalia, there you go.
Hey, thanks so much. Is this the right moment then to say a few words about CYMG? Perfect. Let me share my screen. I also think my connection is a little bit shaky, so please shout if you can't hear me well, and I'll try to improve something. Give me a second. Okay, let me know when you can see it. Oh. Can you see the deck? Okay, perfect. So thank you all again. I'm just going to start with a very quick introduction to CYMG and to the UN Environment Program as well. Hopefully this is helpful context for some of you. I know you're all very, very excited for the content of the lectures, so I'll try not to take up too much of your time. But hopefully this is interesting and helpful for context as well. Okay, so just starting with a few words about UNEP. So the UN Environment Program is an agency coordinating global environmental action. It works to address what they call the triple planetary crisis. Many definitions of that, but for UNEP, that means climate change, biodiversity loss, and pollution. And UNEP works on that through four main types of activities. So that is firstly norm setting and environmental governance. And that is also what we're going to be learning about during the series. Secondly, environmental science policy interface, advocacy and communications, and lastly, capacity building and technical assistance working on the ground with countries and communities. And when it comes to CYMG engagement modalities, so the Children Youth Major Group, we're focusing on the top 3 activities. Oh, it's not switching. Oh, okay. So civil society engagement within the UN Environment Program happens through what we call 9 major groups. So there's 9 groups that represent different civil society groups. So for example, NGO, workers and trade unions, farmers and indigenous peoples, and children youth is one of those major groups. So CYMG is mandated to coordinate youth engagement in UNEP processes. We are a formal youth engagement mechanism to UNEP. We have a membership of over 900 youth organizations, 64 of which are accredited to the UN Environment Program, and we also have over 9,000 individual members from over 100 countries. And our mission focuses on advancing empowerment, inclusion, and meaningful engagement of youth in global environmental governance. And on the right-hand side, you can just see some quick numbers about CYMG. Moving on, when it comes to our theory of change, we're focusing on strengthening youth engagement and driving ambition environmental governance through 3 key avenues. So that is firstly capacity building. So this series would be an example of that, developing skills and knowledge of the young people who want to engage in global environmental governance. Secondly, policy advocacy, so actually formulating policy positions and advocating for them within UNEP as well as other environmental processes. And then finally, expanding access. So that means actually making it possible for young people to show up and attend those important processes and make sure that their voice is heard. And on the right-hand side, you can just see some examples of activities. Okay, so just an overview of some of the key processes we're engaging in. Throughout each year, we would provide input into approximately 30 or so processes. However, that will vary. The key process that we engage in is the United Nations Environment Assembly, which means which is the world's highest level environmental governance body. But there is also a range of other processes. So that includes UNEP-administered multilateral environmental agreements and scientific assessments. So the Montreal Protocol here is an example. And for scientific assessments, for example, the IPCC or the International Resource Panel. And then finally, on the right-hand side, UNEP-facilitated initiatives and partnerships. So for example, the UN Environment Management Group, the UNEP Finance Initiative, etc. Moving on. Won't spend too much time here, but this is just a few quick numbers to highlight what we've been able to achieve so far as CYMG. And more achievements from 2024 specifically, so just to flag a few examples. We participated in UNEA 6 last year, and we were able to support 200 youth delegates to take part in meetings in person. We also organized the Youth Environment Assembly, which brought together more than 450 youth delegates. Secondly, we engaged in a range of ongoing processes that we've been engaging in for a while. So that includes, of course, plastics treaty negotiation, regional meetings on OX science policy, but also UNEP Working Group on Nitrogen, for example, UN Decade on Ecosystem Restoration, and a range of other processes. And then lastly, in 2024, we also had a number of first-time initiatives. So for example, or engaging in the Montreal Ozone Protocol MOPS 36, working together with the International Resource Panel and others. And then just a very quick overview of our governance. I think no need to go into detail, but just so you have a quick overview. And moving on to people and leadership. Again, won't spend too much time here, but some of those faces might be familiar to some of you, and we can also share that deck later. So if you're looking to get engaged in any of CYMG's areas, you can also contact the right people that are working in those spaces. Our steering committee actually brings together almost 50 people, so you can see an overview of all of them here. And then 2 more points, I think. So firstly, this year, all of our efforts are focusing on the UN Environment Assembly in 7th session, which will be happening later this year. And in the lead up to that, we have a range of engagements that you can see on the screen. So as always, a number of processes that we'll be focusing on this year. And then lastly, how can you get engaged? So if beyond joining this session, you're interested in getting involved in CYMG, which I would, of course, absolutely encourage you to do, there is a few things you can do. So the baseline would be that you just stay up to date, and hopefully you might already be subscribed to our mailing list. And if you're not, please feel free to do that if you're interested. Secondly, what you can do is provide ad hoc input into a range of processes. So if you are subscribed to our mailing list, we'll be sharing a number of opportunities to provide input, join consultations, etc. And that way you can contribute to developing inputs that will be then forming a position of Children Youth Major Group on ongoing environmental processes. You can also join project teams and task forces, and we'll actually be launching a call for applications next week. So please stay tuned for that. And then finally, you can take up formal roles within CYMG. Again, a call for applications will be out soon. So please feel free to let us know if you're interested, and follow us on social media where you can learn more about that. And that is it from me. Thank you so much again. And back over to Shannon.
Great. Thank you, Natalia. Now I will introduce the wonderful, I call her one of youth's biggest cheerleaders, Dr. Alexandra Harrington, who will be giving the exciting first lesson on the MEA Bootcamp today. You should be able to unmute yourself, by the way, and I think I gave you sharing.
You did. Look at that. All right. Let me then share my screen. And again, to those of you who've just joined, welcome. It is lovely to have all of you here. And this should be sharing now. Can you see that, Jellen? Yes? No? No? Okay. Let's try this.
Woohoo! Yay!
Excellent. Okay, good. Fantastic. Let me put this into presenter mode. And we will go from there if my computer wants to work with me, which sometimes it does, and sometimes it doesn't. So welcome, all of you. And I know we've had a lot of information. I know that it has been a very intensive morning already for us, or afternoon or evening, depending on where you are. So what we will do in the opening session is kind of start with some of the basics, the background on international law. And then what we'll do on Thursday, or whenever you're next watching this video, if you're watching the video, in the next session is talk more about what is actually in a treaty. So we'll do a breakdown this week of really core concepts of international law and really core concepts for understanding the treaty process. And then we'll get more into the treaty process itself next week and in the weeks that come. And what we'll do finally is, here I should probably move to course background, is to then have the idea of what is our frame of reference for all of this information and all of these details in the plastics treaty, and using the plastics treaty as a basis. For some reason, I'm just going to escape for a second because this is not allowing me to advance the slides properly. There we go. Okay, perfect. If you are unfamiliar with anything having to do with law or international law, that is perfectly fine. I want to start off and make sure that everyone is completely clear on that. We don't need to have a background in international law or even any type of law training, really, to understand a lot of the fundamental aspects that are here and that are present in the course. So it is designed as a course that can be understood by anyone coming into this with an interest. And then obviously, if you do have a bit more background, you will know and you will understand more of the nuances. And obviously, if you have questions that are a bit more nuanced, please ask them. And I'm happy to address those as well as very basic questions. There are, to me, no silly questions. There are just questions. The silly questions are the ones that you don't ask. So please ask questions. We will do our best to get to them. Shellen, do you want to explain quickly how we're collecting the questions, just so everyone knows how this will be handled? And
Yes.
yeah.
So we have some wonderful help. I will just, then I'll put you back in the spotlight, Alex.
No, please.
We have some wonderful help. So we're going to collect similar questions. And then so people in the chat will be collecting the questions, and then at the end, we'll try to answer similar questions. There's also going to be a discussion session as well on Saturday, Sunday, depending where you are.
Thank you, Shellen. So yes, please put questions in the chat. Please do share whatever comes to your mind. If it comes to your mind, most likely someone else will be thinking it they might not want to ask. So please do ask questions as we move along. And yeah, we do hope that you're able to make the discussion sections on the weekend, obviously understanding that it's the weekend. So if you're not, then we'll be able to share information with you from that as well. we are using the background of the Intergovernmental Negotiating Committee for an international legally binding instrument addressing plastic pollution, also known as the INC process, as a framework for analysis. So as a framework for putting into place all of the things that we'll be learning in the beginning of this course, and then seeing how they have evolved and how they have worked. Because this is something that is quite new. It's quite new. It is unusual as much as we think of international law and international treaty practice as obviously based on treaties and agreements. It is quite new and novel to have an entirely new treaty being negotiated. It is not something that happens that frequently. And even when we think about things like the Paris Agreement, for example, from the UN Framework Convention on Climate Change, the UNFCCC, this was something that was negotiated within the framework, within the parameters of an existing process within the UNFCCC system. The INC process for the plastics treaty is different. And the INC process was authorized by UNEA, so the UN Environment Assembly, and it is being conducted with assistance from the UN Environment Program, from UNEP, especially in terms of secretariat function, et cetera, and having a separate secretariat set up within the UN and UNEP system. But it is an entirely new treaty that is being negotiated, and there isn't that background session that we have from UNFCCC to, for example, to provide us with a reference point. So this is a really new and very interesting process that shows us how international law works, how international treaty law works, and also how we then get to the treaties that we have to put into place, and how that might work into the future. So that's why we've chosen this particular lens as the discussion point. And just to highlight that by the end of this course, what we hope, what we want, what we intend is for you to come out with a better understanding of what international law is generally, and also how it applies to the treaty process. What the key steps are in the treaty process, in the process of making a treaty, and in the process of negotiating it, what goes into these discussions. And especially for those of you who will be attending the INC or participating, it's also to give you a sense of what is really going on, what is the understanding of the room when something happens, what does it mean? So you have the ability to participate as fully as you can, and to bring the voices that you may represent as completely as you can, without having the obstacles of trying to learn. And I think Shellen always uses this example of when she first came to an INC, and I know you won't mind me saying this, and she felt shell-shocked. And actually, we met shortly thereafter, and started these discussions, because it can be quite intimidating and it can be quite just overwhelming. So the idea is to make it a bit less so for all of you. And even if you're not going to be part of the INC process, for you to understand what goes into making a treaty, what goes into these decisions, so that you can be an advocate for the communities you work with, the constituencies you work with, and also for yourself, as, for example, the plastics treaty is being put into place, but also as other treaties are being put into place, and even as national laws are being created. So the idea is really to be very much empowering for you. Please do excuse the occasional sip of water. So moving on to some general concepts. First and foremost, what is international law? This is something that we're asked all the time. International lawyers get it a great deal in terms of, it's not a very hard science in a way. There's no statute book the way we have for many other jurisdictions. What is it? And then the first question is, where does it apply? And so this is a very important question. Where does international law apply? It applies, as the graphic might suggest, globally, to the extent that it is agreed to by various countries. And in international law, what we refer to as countries typically are states. So when we say states, we say it, and when we write it, we say it typically with a capital S. For those of you who are from national jurisdictions where you may have states that are the equivalent of provinces that are subnational units, it is very confusing. Certainly when I've taught international law in the US, it tends to be very confusing. But when we refer to states in the international law system, we are referring to countries. And international law is made of countries and country decisions. Thus, international law applies globally, but it applies globally to the extent that various countries have made commitments to be part of it and to agree to whatever either customary or treaty-based, and we'll get to that momentarily, norms the particular international system at the time might want to put into place. So it is a bit more complex than just saying it applies globally. It would be lovely if it all did, but it typically doesn't, unfortunately. Now, if we move on to where does it apply in terms of countries, it applies to countries that agree to be bound to international law. So when we say international law, what we're typically talking about, which we will get to in a second, is the idea of things like treaties, the idea of things like customary law and practice. So things that various countries or various states agree to. And agreement here is key. The way that the international law system works, and certainly we see this in the UN, in the UN Charter, but also generally as accepted practice in international law, is that the state, the countries, they are the ultimate body. They are the primary holder of sovereignty, and they have the highest amount of rights and the highest amounts of responsibilities as a concomitant measure in the international law community. Thus, what we understand is that when we're looking at international law, it is made by states between themselves. In this calculation, there are many people, but those people represent states, and people become very critical, understanding personalities, understanding points of view, understanding how all of these things work together is something that we'll talk about when we get to the treaty negotiation process. But understanding from the beginning that the way international law functions is to be primarily state-based. So it is primarily state-based, it is primarily created by states. And this can be a little bit frustrating, especially as we're all sitting here in a major group discussion, because the question tends to be if international law is geared to reflect the sovereignty of states, which is considered to be the highest level of sovereignty, the highest level of rights that can be held in the international community as a matter of law. How do we create a space for other viewpoints? And how do we make sure that other viewpoints come into, for example, the negotiation process, than only states? And it has been a fight, and it often continues to be a fight to have that type of presence available, especially at negotiations or the implementation process throughout, for example, Conference of the Parties in the future. But there has been a great deal done to get recognition and to get voices at the table. So as we talk about international law today and into Thursday's discussion, and we're talking really about state-centered activity and international law norms, I do want you to remember that there is a place for outside voices that are not state voices. And there is a place for us to have perspectives from children and youth, from other major groups, from stakeholders or observers, as I think the more accepted term is now, and to really incorporate outside views, as much as it is important to understand that this is the result of a fight, and it continues to be in many instances a struggle to get in non-state voices. And this background really is intended to explain to you why. So when we think about international law applying to states, this is again because states make it. States sit down at the table and negotiate. Now, obviously, a state does not sit down, its representatives sit down. It's representatives who are representatives of a government and a time and a set of priorities sit down at a table or at a series of rows, as in the negotiation process for a multilateral treaty. And they sit down and they negotiate together, and then they try to implement it together. But we do have to go through a process to get a state to actually be bound for international law purposes. And this is very different than what we think of at the national level, which is often in international law called the domestic level. So at the national level, we typically think of power as being structured kind of vertically. So power comes ultimately from the national government, from the highest government level under the Constitution, then moves down to perhaps a province or a sub political unit, a sub-state unit, then perhaps to a county or a parish or something like that, depending on where you're located, and then to a city or a town or a village, and ultimately to the individual. And everyone is bound, everyone has a certain responsibility, and that's very clear. Everyone, with the exception of obviously individuals who are required to follow the law and also hold rights, the other sub-units, sub-government units, make laws within their ability. So a municipality can make, for example, laws about rubbish collection and waste collection and things like that, but it has to function within the structure where there are several layers above it that can direct it. And this is typically what we think of for national legal systems. International law is quite different. International law, we often explain as being horizontal. So there are multiple countries and they all work together, but they are all on this horizontal line because, and actually it's perfect because there is a line in my background. So there we go. If you think about that line right here as being states that are negotiating or states that are actually implementing law, they're all considered to be equal. They are all considered to be sovereign. And so there's nothing above them. They are all considered to be the highest level. And this is also one of the reasons that we see a process when we think about how international law works and then how it functions with national law. This is one of the reasons that we think about this as a process that does have to work together, because the states are horizontal on this line here, but then when they go home, they have to take whatever they agree to. So if, for example, we have a plastics treaty soon, as we all hope, then once that is agreed to, the states that are part of it still have to go take that national measure home and make it binding domestically. So make it a part of their laws, however that is required under their constitutional system. And I think this is one of the things to highlight to you early on, and I'll keep coming back to this to remind you that once there is an agreement under international law on a treaty, whether it is a multilateral treaty, which is what we call any treaty, that any agreement that is between more than two states. So it can be between three states. For example, the US-Mexico-Canada agreement, USMCA or CUSMA, depending on where you are, for trade is between three states, the US, Mexico, and Canada. However, it is considered a multilateral agreement. At the same time, the Convention on the Rights of the Child, which is one of the most universally ratified treaties in the world and stands at nearly universal adoption and ratification except for about 3 or 4 countries at this point, is also considered to be a multilateral treaty. So anything more than 3, or pardon me, more than 2 countries, so 3 or more, becomes multilateral. That is one terminology to know. The other terminology to know is that if we are looking at a treaty between two countries, that is called bilateral. It is a bilateral treaty. So we have both. The process for both typically is the same domestically. So once a country signs onto it, once it says we agree in principle to what is in the treaty text, typically, there are some exceptions, but typically the state is not legally yet bound. They don't have to do anything yet. What they have to do is take that treaty back home and then take it through a domestic process that varies by country. It varies by country, it varies often by constitution. Typically, a constitution will set out at least some of the parameters for what's going on and what needs to be done. And then it has to become adopted very much like any other legislative matter at home in order for it to be legally binding and for us to say that it has been ratified, which is the term we use, ratification. And then a state is considered both nationally and internationally to be bound by the treaty. So there is still a process, and we will go through this again and again because I know it is a lot to go through. But there is a process by which we take international law from the high level global system and put it into the national system. And I really want you to think about that from the beginning and to know that from the beginning, so that we don't just think that we're talking about something that's really high level, but it's very difficult to translate to the ground because it isn't. It's just knowing the steps and knowing the process. And especially as we're coming upon treaties that are relatively new. So, for example, not only the hopefully soon to be agreed to plastics treaty, but also things like the biodiversity beyond national jurisdiction, the BBNJ treaty. These are things that are currently being discussed, and in the BB&J case, currently up for many types of negotiations for ratification at the home level, at the national level. So knowing about this process is also important for those of you who are advising constituencies or working with community groups, etc., because it will help you to figure out how to place yourselves in these discussions and what discussions you might want to engage with. Now, this gets to a very interesting question. So we know, obviously, treaties give us a great deal of international law, but where else does it come from? Because we've talked about international law historically for a very long time. You can't see my background, but if you could see it without the leaf, there would be a very nice set of many books talking about the international law history, etc., and it is much more than simply treaties. So international law comes from a number of sources, a number of places. It has evolved over time. It has a very long history, and what we tend to look at in the modern context is the statute that comes to us for the International Court of Justice, what we often refer to as the ICJ. And the ICJ has very kindly set out, or the states that created the ICJ have very kindly set out in the statute governing its operations, a set of factors that we will get to momentarily, and a set of sources for international law. And not only have they very kindly set out the sources, they have also very kindly ranked them in terms of saying which has more value when you are making an argument, which has more value, which do you want to argue first, which do you want to argue last, or if you're only relying on certain types of cases, when might you not, or precedent, when might you not want to make a case? Now, this only applies to the International Court of Justice. Pardon me. However, this has become very much the standard adopted in international law practice. So when we talk about sources of international law, we typically go directly to the statute and have this conversation. But it is also important to remember that international law has a very long history. And so we often draw on that history throughout the discussion of where does it come from. So what are these sources of international law? According to the statute of the ICJ, what are the sources? There are 4 categories. They are ranked, as I mentioned. So the most valuable under the ICJ statute, and thus international law practice, tend to be the treaties, the agreements, or other binding instruments, followed by customary international law, and then general principles of international law and jurisprudence of cases. We'll get into what these mean momentarily, and also academic writings, because it is important to remind academics such as myself that our writings may be valuable to many, but ultimately we need to know our ranking role, which is to say last. But all joking aside, when we look at treaties and agreements first, there are a number of different words that can indicate to us whether an instrument is considered to be binding or not, or what we often would call hard law in the international law context. And when we say hard law, what we mean is that the treaty itself has obligatory elements in it. It becomes, once a state has signed it and they've taken it home and they've ratified it, it becomes binding upon them. And they have certain obligations that they must do or they must not do as a result of the treaty. So it's not simply a commitment of states to try to do something or to encourage a practice or to discourage a practice. It is an obligation, a positive obligation of a state to do something or not to do something as it is required under the terms of the treaty. And when we're looking to determine elements of bindingness, because treaties will certainly have some elements that are not binding. This is part of the negotiation process and the reality of many issues that come up. What we do is we look to see whether or not the treaty contains some critical words. So we look and we see on textual analysis, does it use things like the word shall, or the word must, or shall not, or must not? If those words are used, this is a very good indication that the treaty has certainly binding elements and will become binding. It will have the name of treaty, it will have the name of agreement, it will be legally binding upon the states to which have become state parties, so which have ratified it. And typically, when we are looking at the name of a legal instrument in international law, we can tell whether it is intended to be binding or hard law by looking at the name. So if it is referred to as a treaty, if it was referred to as an agreement, if it is referred to as a convention or a covenant, as we often see in the human rights context, these are examples of triggers that will tell you in your mind, this is intended to be a treaty. It is intended to be a binding law instrument. And that is the highest ranked international law option that we have, source that we have. It is also important to remember that from treaties and agreements also come a number of decisions. So when we get to the idea of what goes into a treaty, we'll talk about the governance systems, and we'll talk about things like conferences of the parties that meet to address certain issues which come up for the overall application of the treaty and how it might grow in the future. Those decisions of the states also fall under the general ambit of treaties and agreements. So if we're looking at, for example, interpretive questions for the Paris Agreement or for the UNFCCC system, we would look not only at what is in the treaty, we could also look at supporting sources like what comes out of the conferences of the parties. So just to remind you that that element also fits into treaty analysis as a source, as the first source. So this is great. We have a first source. What is the second source? Customary international law. Often we think about this as including what we call soft law. And soft law is unfairly named, I think in many ways we could say that, because it is in many instances certainly as persuasive and as valuable as a hard law commitment. But for many reasons, it might not necessarily be put in a binding instrument. Now, we often see this in instances where there is something new coming up quite quickly, and it's difficult to get a treaty in place that fully addresses the questions that come up. Recent examples include things like AI regulation, things like privacy, all of these issues, which become very important and have evolved quite quickly in the international sphere, are sometimes quite difficult to sit down and negotiate a treaty for, because as we will discuss over the next several weeks, this takes a very long time and it is a very intensive process. But what we can see are sets of norms. We can see non-binding measures that come into place that can be considered and argued to reflect custom. They are still very valuable and they are still sources of international law. They just don't carry the same legal weight. So we think about trigger words. If we're looking at something, a text, how do we know if it is voluntary, if it is soft law? The first thing we can do is look at the text and the actual title. If it's something like a declaration, so something issued by the UN General Assembly, for example, that is considered to be a soft law instrument, so it would be more customary. If we're looking at things that might be guidelines or frameworks or recommendations, these are all words that should trigger to you. They are not legally binding as a matter of international law in the same way that a treaty or an agreement might be, but they still carry legal weight. And additionally, we should point out that customary international law also includes the idea of norms. And the idea of what, in the very negative or often criminal context, we talk about as jus cogens norms. I know that the translation will absolutely not get that right because it is Latin terminology, so that's fine. But what this means is this is something that is considered to be a very high level of norm, typically something that the international community can be said to have agreed is a bad practice and should not be done. Often these are later codified in a treaty, but until that point, we have them as norms. So previous examples of customary international law are things like prohibitions on slavery, prohibitions on genocide, prohibitions on other aspects of war crimes, on piracy, etc. So very high level things that are typically agreed upon as negative before there is a treaty to codify them. So that tends to fall into the idea of customary international law. And under customary international law, there is a very specific test that we use. Those of you who are either law students or law graduates may remember it. We look at whether the state, there is a belief by the state that it has to do something or not do something, and that there will be a consequence if it doesn't. So that is how we typically evaluate customary international law. When we get to general principles of international law, there is the idea that there are some things that are universally binding, even across legal systems. So even if we're looking at a common law system or a civil law system, there are some things like non-retroactivity. So if a law goes into place today, if an international law goes into place today, or if one goes into place domestically, either in a civil law or common law or many other legal systems, you cannot be prosecuted for it. If it's a traffic law and it says that you have to cross at a certain time, if yesterday you crossed at a different time, you cannot be prosecuted for the law because it goes into effect today. So it's the idea of non-retroactivity is that you cannot be prosecuted or held responsible for something that was legal at the time, but subsequently became illegal. or regulated it in a different way. That is the example or an example of a general principle of international law. So it's something we all agree on, typically, or most of the international community does. And then finally, we have jurisprudence and academic writings. So case law, cases, cases from different jurisdictions, cases from different international tribunals, because the way international law typically works is that if you go to, for example, the International Court of Justice, if you're a state and you go to the International Court of Justice to bring a claim against another state, whatever the International Court of Justice says will be binding on you and the state that you have brought to the court. But it will not be binding, it will not be required for anybody else, because everyone else is considered to be a sovereign. And so they, unless they bring their own claims and they have their own arguments, it is not considered to be binding upon them. It is very persuasive, and so you can argue that a court in the past has said this or that, but it is not as weighty as an argument as having a treaty. And obviously, national court decisions come in, they can come into play. They certainly can come into play to establish custom, but they are not considered to be the highest level of source in international law. And then writings by people like me are classified as last. I know my place in the world. I do. It's all right. Anyway, so if someone writes something that is particularly useful and particularly pithy, that is wonderful, that is great, and can be included in a source, but it is not the thing you want to run to first, believe it or not, despite all of my academic writings. It really isn't. There are other things that are much more valuable. And finally, because I don't want to take up too much time or go over the hour too long, just some basic questions of how is international law enforced and what type of oversight mechanisms are used. This is very different. So if you're used to practicing, if any of you are practicing lawyers or you're training to be lawyers, it is very different than what we think about at a national system, where you go to a court, typically you get a decision from the court, you can put it in place immediately, and that is it, that is binding. In international law, as I mentioned, the claims tend to be only involving one state against the other, or sometimes a few states. And the outcomes are only binding, only legally binding on the states that are involved. We do have some exceptions to this, for example, in the human rights context, and that's a whole other discussion we can certainly have in the future. And if any of you want to have a discussion on that, I'm happy to. And perhaps that becomes the next thing we talk about, Chellen, but deciding. But for the environmental context, certainly up until this point, it really is a state-based argument until you get to national litigation, for example, climate litigation. That is done in an international court and sometimes uses international commitments. So, for example, the various NDCs, the nationally determined contributions that are filed by countries under the UNFCCC and Paris systems, when they have been used recently by various litigants in claims against states for violating their climate change obligations. So that's a bit of a different argument. But other than that, particularly in the environmental context, what we see is the idea of oversight mechanisms in international law being created in treaties and being created by treaty obligations. So things like compliance committees from the Paris Agreement, for example, the Paris Agreement Compliance Committee, to hold states accountable for how they are or are not complying with their commitments under various international treaty systems. And this is often what we see. We see some greater success with this than others. For example, the Aarhus Convention, which is very much a well-known convention in the concept of access to information in environmental contexts, has a very well-functioning system for receiving complaints against states and then evaluating them, and having really comprehensive judgments. Those have then been used as the basis for also the Escazú Agreement, that system for the Escazú Agreement, which covers very similar concepts, which is for Latin America and Caribbean, and which also addresses things like environmental defenders. So I wanted to highlight this, and we'll end on this for today, and we'll get into what is treaty law on Thursday. But I wanted to highlight this to you so that you can think about not only what is international law, where does it come from, why are treaties so important, but also why is it important that when we think about treaties, we think about not only the obligations that they create, but also how we enforce them. Because in the international law context, it's very important that we have a treaty system that addresses this type of issue from the beginning, from the outset, so that we can know not only what type of law we're making, but also how we put it into place. Because that is, at the end of the day, what many of us, especially those of you who are involved in various forms of community activities or advocacy, etc., are here to do and are here to learn about. So I will end here. I think that's almost on time. Shellen, I apologize if I went a minute or two over. I have other slides. Obviously, those are for next time, so I will add some more fun graphics. So it's not just boring text. I promise I am slowly learning. I will end this now, and then if I can figure out how to stop sharing my screen, I think I did. Did I? Are you still seeing my screen, Shellen?
I am. Let's see. I can do it. There we
There
go.
you go.
Awesome.
Thank you.
This was wonderful, and I can see a lot of great comments in the chat here. So let's go to some questions, because there's some great questions, and I cannot think of a better question to start off with. This is from Andrea. I apologize for if I mispronounce your names. My name gets mispronounced all the time. When negotiations happen, the only representatives are the government ones, or is it possible for other kind of representatives to sit at the table? Hence, some of us are those representatives.
I'm so glad that you asked this question. Thank you very, very much. So yes, typically what happens in a negotiation is that you have all the states. I really should we should diagram the room, Shellen, we should, or just like share a photo. I'll get a photo for next time. I'll put it in the slideshow. So you have seating where it's all the states kind of first ahead in a room. And then depending on what the situation is, depending on what the organization is, in UNEP, for example, for the plastics treaty, there is a separate section for what we call observers. And observers are everybody else who's not a state. So if you represent a UN agency, you're an observer. If you represent an intergovernmental organization, you're an observer. If you represent children and youth, you're an observer. If you represent a community organization that is accredited with the UN in some way, then you are an observer. And the key here is that you can't walk in off the street and join the negotiations and sit down. You have to have a badge and have all sorts of other credentials done in advance. And you have to be part of a group that is recognized either by the UN General Assembly or by UNEP and UNEA in order to be present, certainly, at these types of negotiations. That means you can sit in the same room. You sit in the back, so you sit behind the states. And depending on where we are in the negotiation process, certainly at the opening and closing of the plenaries, which again, we'll talk to these different things soon. But you have the ability to raise your flag and to make an intervention after the states. So the states talk first, and this is also true in the negotiation process. Throughout the time, states talk first. And then if there is the opportunity, both in terms of time and in terms of momentum, then there will be an opening opportunity for observers to indicate that they would like to speak, and then they're able to speak. So for example, Shellen, God, looking at myself, Shellen gave a wonderful, I have to just do a shout out with this again, a wonderful set of interventions or intervention at INC 5, and was able to speak for youth and was able to speak about the priorities of youth, etc. So that can be quite powerful to have at the table. But at the end of the day, the only voice actually going towards voting will be the states themselves. Which is a very long answer, but we'll go through that whole process again. And I should point out there was one exception to this. And I point this out because I think it will probably continue on in its life. And that was the CYMG process, which was the very long, like 16 years long process of negotiating ultimately the global framework on chemicals, which was agreed to in 2023. And they're having their first meeting in Uruguay this June. But during that process, because it was to create a soft law instrument, so the global framework on chemicals, it's a framework, it is not legally binding. That process, because it wasn't a soft law process, actually allowed for observers to have equal footing in terms of being able to intervene and to speak at any time. So we didn't have to wait until countries went first. We could go anytime. We still didn't get to vote, but we did get to speak in order of kind of topic that came up, and we didn't have to wait. So that was slightly different. So that's that, Shellen. I think I answered that more than anybody probably needed to know.
You did. And one thing about Dr. Harrington, as you guys can all see, is just so much passion for this topic. So there's some really great questions, actually, I must say. So let me ask the next one. So despite a state being part of an agreement, it will not be considered legally binding until the state follows a domestic process to apply it. Yes or no?
Yes. Yeah, absolutely. And just to explain, so that's why when you see, if you're looking at a treaty text, and again, we'll get into this more as we get deeper into the sessions, but when you're looking at a treaty text, towards the end, typically there will be something that is a clause on entry into force. And it will say this treaty will enter into force, say 90 or days or 6 months or a year or however long after the, say, 50th ratification. So that means that you have to have 50 states. 50 is typically the number used in environmental treaties that go through the domestic process and that ratify first. And then at that point, the treaty will become legally binding. It becomes legally binding, first of all, on those states that have ratified, and then on all subsequent states as they ratify. And the idea there is that you can create a brilliant treaty, but if no one ratifies it, or if only 2 countries ratify it, probably not going to have a lot of international impact. So the idea of putting it into practice needs to wait until we have a good constituency, a good core there. Now, in environmental treaties, typically it's 50, sometimes it's 60. So BB&J, for example, is 60. In other contexts, you will see other measures. So like the chemical weapons treaties or some of the biological weapons, etc., the nuclear weapons, that will have a percentage threshold. So it won't come into effect until a certain percentage of countries that hold, for example, nuclear weapons are actually able to sign and ratify. Because again, if you have all non-nuclear states that are signing it, that's wonderful. It's commitment, but it's also not going to limit what you're trying to limit. So
I really think as hard as negotiations have been, we're really at the easiest part at the moment, aren't we?
most likely, yes, absolutely.
The next question I have, are non-binding norms counted as well?
Non-binding norms are counted, and they typically are counted as custom. They fall under the customary aspects.
And there's some really great questions. I know, yeah, I know how much saved you time, so we'll try to get through as many as possible as long as you guys are willing to stay here. The next question I have is, does legally binding treaties always require a review mechanism, such as plenary for non-compliance?
They don't always, they don't have to, but typically the standard practice is that they have. And the idea is that you have some way of making sure if you are making a commitment as a state, that other states are following the same commitment. So if you're looking at it from the state perspective, you want to be able to say, yes, I'm giving up a piece of my sovereignty. I'm giving up a piece of my rights by making this commitment. And everybody else who's doing that is also going to have a review to make sure they're doing it in the same way. or they're doing it with equal measure. Certainly from the outside perspective, we want that. So if we're thinking about observers, we want to have that because we want to be able to get information. And we also want there to be a system to hold states accountable. But it isn't a requirement. It isn't technically a requirement. It just has become a very common practice.
Great. And here's the next question. I think it's very on topic is, how about codes? Are those customary or treaties? And they're giving the example of the Maritime Labor Code.
So the Maritime Labor Code becomes a treaty when it is adopted, or becomes a treaty equivalent when it is adopted by a state. When it is made simply by a secretariat, or when it is proposed during a negotiation, is not. But as soon as a state agrees to it and adopts it, then it becomes considered the equivalent of a treaty.
Wonderful, wonderful. I know we have a great team helping us in the chat as well, so I'm seeing all your questions. The next question I have, is it up for individuals to interpret from the document's title whether the document is binding or non-binding, i.e. is a treaty or something a source? Shall it not be stated already for better transparency?
So typically, again, the name is a very good giveaway. And I've never seen anything that's called an agreement that isn't legally binding, or a treaty that isn't legally binding. But you do have to look to the contents. And so what you will do is you will make an argument. If you're making an argument, for example, to the International Court of Justice or anyone else, your argument won't be, it's called a treaty, so it's legally binding. Your argument will be, under these provisions, there are legal obligations that are binding on international, as a matter of international law, and on states in the international law system. It provides a state shall do X, Y, and Z. So that is where the legal obligation comes from.
Great. And here, continuing on with all this, at a high level, how are litigations different in international versus domestic law?
So there are many, and we could do a course on this. We could actually do a really fun session on this. There are many ways. I think the first thing is that, when we think about national law, first of all, it's very difficult typically to bring a country into a national law jurisdiction, right? It's super difficult. And sometimes there are specific venues, depending on the country, where you can bring a litigation claim against a country. At the international law level, obviously, that isn't the case. Often the evidentiary requirements are different, the procedures are different, and at the end of the day, the outcome is different. So if we have a decision of the International Court of Justice for one country against another country, that is a decision. It is not necessarily going to be put into place right away. It can be subject to then diplomatic discussion and negotiation. So that might be the decision, but then there is an agreement by the parties, okay, we're actually going to do something slightly different once political pressure has come and legal pressure from the decision. We see this a lot in things like World Trade Organization dispute settlements as well, where we may have a panel decision that goes against a country or for a country, and then there is a negotiation back and forth on how to fix the problem between the countries. It's different. Also, it is only binding on the countries. And there is the ability of the countries to actually ignore a decision in a way that you can't do if you are an individual. If you are an individual and you are fined for a regulatory aspect of non-compliance with environmental law, I would highly recommend that you pay the fine. And if you don't pay the fine, there will be some government officials that are very angry at you and they will come after you. If you are a country and the International Court of Justice says you should do this or you must do this, and you don't, the punishment is that the ICJ says you're being a bad actor. And if you push it long enough, you could have your UN membership suspended. But typically, those are the only options. So the punishment level is a little difficult too. And it's very different.
So let's go to the 30, as much as we could talk about this for hours.
Yeah, absolutely. And then if we have other questions that don't get answered, we can also talk about them on Saturday or
Yes.
Sunday.
Yes. So there's some really great questions here,
Oh,
though,
there
I
are.
must say. Yeah, there's some really great questions. So let's go to the next one. How can states balance their sovereign right to exploit their own natural resources with their responsibility to ensure that activities within their jurisdiction or control does not cause environmental damage to other states or area beyond national jurisdiction?
This is such a great question. So we do actually have some legal precedent for that. So in what I call the dam case, what we all call the dam case, because no one wants to slaughter either the Hungarian or Czech language. From approximately 30 years ago, the International Court of Justice actually established this idea of there being an obligation to have transboundary information sharing in the event of an activity that may cause damage to another state. And even if that includes exploiting its own resources, some type of environmental impact assessment process. So if you are a state, as in the case, where you wanted to build a dam on a shared resource, which was the Danube River, then before you're able to do that, you would have to talk to, negotiate with, or certainly include in the environmental impact assessment and give them a chance to participate the other state that may be impacted, rather than just saying, I'm building a dam, it's in my territory, I'm going to do it. Because there is an idea that shared environmental resources are very different, and shared environmental resources are things that need to be protected for all countries that share them, not only the one that tends to be, let's say, first to get access because of where they are geographically. And that has become a principle. It's become a principle of international law. It is often included in international treaties through the preamble, but also then through things like the principles that run throughout it. And it does have a set of kind of early life forms coming from the Rio Declaration. So when you see a reference in a treaty to Rio Declaration principles, typically this is included as well. So that's how we often see the attempt to balance both is at least information sharing, and then the option for a potentially impacted state to be part of the information gathering and decision process. Although obviously it doesn't get to make that decision, it gets to be heavily involved in it.
Right. And so here is the next few. They're kind of all very similar. So, it's about what if a country violates a treaty proposition, or, how can international law hold can legally accountable for failing to meet their commitments under agreement, and what are the consequences, such as violating the Paris Accords?
Yeah. So there are several ways that this can happen. States typically under any treaty regime have the ability, if they have exhausted negotiations between each other, to go to the International Court of Justice and to make a claim against one or the other or a group of states regarding their failure to comply with any of the treaty obligations that they may be party of, as long as that treaty allows them to do so. So that's why it's also critical when we look at the treaty text and we talk about treaty negotiations and drafting, that we look at these little things that are at the end, and often because they're at the end, they get kind of glossed over, that are really important, like whether or not a treaty can be taken to the ICJ, whether the ICJ has jurisdiction, because sometimes it doesn't, and it won't unless that jurisdiction is actually given to it. So there is that aspect. And once that happens, then there is a proper procedure, proper filing, etc. There are also options, depending on the system, certainly in the Paris Agreement, to have an internal complaint discussion. So there is a complaint mechanism that is created, and that complaint mechanism allows for certain individuals or certain groups and states to bring complaints. And it is a specialized body within the treaty process that has members nominated typically by the states. Usually they will be geographically representative of the 5 geographic regions that the UN recognizes and organizes with, and typically have a gender balance. And there will be an effort using that to decide whether or not there is a violation of compliance. Now, if you have an ICJ decision on an interpretation question, et cetera, or an application question, that is binding on the two parties, and it will be punitive in the sense that there will be a finding. Okay, this state did not do X, Y, and Z. If you go through the compliance mechanism, depending on how it's created, so if we're looking at Paris, certainly under that compliance mechanism, it is specified to be what we call non-punitive. And by non-punitive, it means that this will not be able to establish, say, a monetary damage threshold, or say you have to do this, this, and this as a requirement. Instead, what it will say is we find that there are issues with compliance under the following articles. We suggest certain measures. So it's a softer thing. It's not a requirement like a judgment, it's a suggestion. And then from that suggestion, there's a larger set of learnings, a larger lesson that is then framed for the international community. So it doesn't just seem like there's a finding that one state did something incorrect, but actually that this is something other states could do as well, and this is how we would fix it. So there's a difference in that language. The other thing to remember is that we are seeing a lot of climate litigation. And we are seeing moves by people, for example, to use biodiversity litigation. There actually is even talk about potentially using litigation in the plastics context, for example, to enforce at the domestic level state commitments that they have made through ratifying and through trying to implement the ratification process as well. So there is that other aspect, but that would then be in the national jurisdiction rather than international.
Amazing. And yes, I have to agree. I love some of these responses and questions, you know,
I
just
know,
how
they're
great.
so fun. This is really great. It's so much fun.
So I think also we're about to see potentially a major ruling, and this is the ruling that we're waited on by the Pacific Island students. Is that similar to what you've been discussing in the ICJ?
Absolutely. So the only difference is that that case is asking for an advisory opinion. And I should kind of, as a transparency thing, just explain that I was one of the co-counsels for IUCN on it. So in writing the brief, not in actually doing the presentation, that is a whole different level, but in writing the brief or briefs that were filed. So I should just put that out there as a general comment. But that case was a request for an advisory opinion. So there are two different types of cases the ICJ can hear. One is where there's an active complaint, one state against another, for something like the dam case, right, where there is an active conflict. The other is where a state or a group of states in this particular instance have come together and are asking the ICJ for an opinion, an advisory opinion on a question, a legal question that is within its jurisdiction. Now, sometimes we've seen this like in the idea of the nuclear weapons use case, so the advisory opinion from the ICJ on nuclear weapons as to what state responsibility is for the use of nuclear weapons, whether they can be considered to be illegal or legally not permissible in most contexts, etc. The other is to ask a question about moving forward, what would be a state responsibility? So in this instance, what would be a state responsibility for impacts of climate change, et cetera, on other states? And the ICJ will issue an opinion because it isn't what we would call a live case yet. It's just asking for an opinion. It will explain, we assume, what it considers to be the legal obligations of a state, for example. It will explain what it considers to be the future forward-looking obligations of countries and of the international law system. And the idea here is that we then get a better sense of how do we, say, implement the Paris Agreement, or how do we look at climate change, et cetera. All of these things and climate litigation coming out of the advisory opinion. So it has a different weight because it's not technically binding on anyone, but at the same time, it becomes customary practice amongst all of the international community. And hopefully it will be out soon. We will see.
It's potentially could impact in
Of course.
5.2. So we're kind of impatiently, but patiently waiting for it. I know many around the world are as well. It could impact all of us young people as well a lot.
Absolutely.
the next question, I feel like this resonates also with what you're doing with the legal drafting group. Can international law be applied worldwide in the same way, or does it depend on the laws of each country?
Oh, that is such a great question. So theoretically, yes, it has to be applied the same way, right? It has to be applied the same way. Yeah, a binding provision to ban, for example, plastic bags, if it's in the plastics treaty, would have to apply in the same way. The question then is, okay, there's a ban on plastic bags. How do you actually put it in place? And that's where we see it become much more of a national issue. And that's where we see the enforcement abilities, the technical abilities, the question of capacity building, which is why it's so important. That's where we see it come in, because the obligation is the same, but the question is, how can states put things into place? And that is drastically different, depending on the state and depending on its overall resources and abilities, et cetera.
So another question, and I'm going to actually switch it over to another treaty that you're working on quite a bit right now, the BB&J treaty.
Oh, yeah.
Since international law is primarily based on agreements between states and requires domestic ratification to be binding, how can financial mechanisms such as climate finance, instruments, or carbon markets be integrated into treaties like the BB&J treaty or the plastics treaty to strengthen compliance and implementation? Given the role of customary international law and soft law, can financial incentives help create stronger enforcement norms even when legal obligations are weak?
So I'll get to the first or the latter part first and say yes, absolutely, definitely. Financing is often a very key discussion to getting things moving in a way that sometimes the legal obligations are difficult to advance at the same level. So absolutely, financing can be a critical actor. It can also provide us with examples of good practices that we can include in the legal system. So financing is so important, so very important. It's one of the topics near and dear to my heart. In terms of financing under BB&J and potentially under plastics, so BB&J has the official financing mechanism that was set up that at the moment works through the Global Environment Facility. So it works through the Global Environment Facility. There is an intention to shift some aspects of it over to a separate mechanism over time. But in the meantime, it is working through the Global Environment Facility. And the idea is that it will help to, in the beginning, help countries to ratify and then to implement. And so the ability to link in with compliance really does come with several aspects. It comes with the reporting requirement that the GEF, the Global Environment Facility, has to the Conference of the Parties for Biodiversity every year, or for BB&J every year. There also is that requirement for biodiversity too. I should put that in there. But then also for the policies that the Global Environment Facility itself has. So it has a number of different policies in place, things like gender, things like Indigenous communities, use of environmental impacts, et cetera, to make sure assessments, to make sure that there are aspects of compliance already, which link directly to the treaties, but also link to what we understand as international compliance systems. So those will all go into place. And for BB&J financing, actually, it has already become operational. So the GEF was able to start giving funds to countries that want to go through the ratification process, because in some countries it's quite simple, it's quite easy and straightforward, but in others it's a very long process, or it's a very technically difficult and very stressful process, because sometimes you only have like a year or a time limit to do it. So the GEF has actually started giving out small funding grants for that as well, to help us actually get to then having a ratification process, and the treaty being triggered at 60 countries. So hugely important. And I should point out that financing mechanisms are really critical in the discussions for the plastics treaty. There is a very strong argument right now between countries. So the African group, the African regional group, the GRULAC, which is Latin America and the Caribbean, And many of the small island developing states, the SIDS, have a proposal to create a solely new independent financing mechanism that would run very much like the Montreal Protocol. Many of the WEGO, it's such a weird terminology, but the WEGO, so the Western European and other groups, the EU, the Nordic countries, the US, Canada, etc., have a position where at least for a short period of time or the initial phases, the financing mechanism should be based in the Global Environment Facility. And so this really is a very polarizing argument right now that we're seeing taking place, which also has to do with things like compliance. So it's really important if you're looking at compliance to look at what those arguments are as well.
That is a final question. I know, Charles, I apologize. I wish we could stay longer. And I'm getting so many comments. Yeah, like what an amazing session. And thank you so much. I know I tell you that almost every day, but like how much
thank
we
you.
appreciate you and everybody. And, you know, I think we have so many passionate people about this topic, which is not only exciting, you could share your passion, but also pass down this important knowledge to others who need to hear it in the world.
And that's why we had this conversation at INT5, and that's why, you know, I'm so glad to do this. And thank you so much for all the comments. I really appreciate it. But I think the biggest thanks goes to all of you for being here and to CYMG for organizing it and giving this chance. And this is why we're doing it as a multiple session thing. So I'm very excited to
I
to
feel
see.
like also that during the negotiations itself that we're kind of reminded that the treaty negotiations is very small and kind of intimate, but
Yeah.
because of how it's set up and unfortunately lack of funding for youth and people from the global south, that is something that's very frustrating. But we are working hard, but also we're reminded now here how big the treaty negotiating space and the treaty world actually is.
Oh, exactly. No, it is. And what I also just kind of want as a final thought for the end of the first day, what I want you all to think about is, and to take away, is that there will be places, once we have a treaty, there will be places for you, there will be places for your voice. So don't feel like we're talking about this on a super high level and you'll never have the chance to interact with it, because you will. You know, it's just how, but we need your voices and we need all of these things to be heard, not just now, but also well into the future. As Shellen and I like to joke, when I am retired on a beach, and you can all call me. Anyway.
And just so if you're watching online, the recordings will be posted online. We've gotten a lot of requests for the recordings and the module. I know with the recording, we'll need to discuss the PowerPoints, but I think at least definitely the recordings, and we understand all the different time zones. So whether you seeing this live or you're watching it, thank you so much for attending, and we will see you very excitedly in the next session.
Yes, thank you all. Take care.
Bye.
Bye.